Oh, hey there, folks. Elder Law Care Attorney Patrick Kelleher coming to you from elderlawcare.com. Hey, folks, got a question today from a subscriber from our YouTube channel. Hey, Patrick, what is a QDOT? Well, this right here, folks, is actually a trust. The Internal Revenue Code calls it a QDOT. This is for non-U.S. citizen spouses to get favorable tax treatment, specifically for the metaphorical second-headed monster, which is the estate death tax, okay? So if you live in a state like the Commonwealth of Massachusetts, Massachusetts is one of those 12 states that still has a death tax, and it's only set at $2 million, okay? And listen up, folks, this is extremely important because if you're married to your spouse and your spouse is considered a non-U.S. citizen, say Bill and Mary, married, happily married, right? And Bill's spouse, Mary, is a non-U.S. citizen pursuant to the Internal Revenue Code. The Internal Revenue Code, the IRS, does not give you the same favorable tax treatment as two U.S. citizen spouses for tax planning to reduce or avoid the metaphorical second-headed monster, the estate death tax, whether it's a federal estate tax or the state estate tax, which is a bigger concern for my clients because the state estate tax is at a much lower threshold. The federal estate tax is well over $12 million per person. Massachusetts estate tax is only $2 million. And a lot of our clients are what I refer to as middle-class millionaires. So when you add up the value of their home, their value of their qualified retirement accounts, I just had a meeting with some new clients and they're a little bit over the $2 million. Guess what? When they go up to their clouds, the taxing authority, the estate death tax, has a legal interest in their estate. Here in Massachusetts, if they're in excess of $2 million, okay? Now they have to do an inventory. They have to marshal all the assets, get date of death appraisal valuations on all the assets, the house, the investment assets, the IRA. We'll say Bill checks out first, okay? Say in this situation, they have a $5 million estate. They're going to pay a whopping Massachusetts estate tax if they do not have proper estate tax planning protection in their revocable trust. So Bill and Mary, my recommendation to them is, hey, let's create a tax planning trust in a revocable trust. So it's a revocable trust, okay, for starters, but it needs to have the requisite tax planning in there, okay, called marital trust, this guy here, and a bypass trust. And I'm going to explain in a moment how it works, but also the unique provisions needed for this guy up here, QDOT, because of this situation. The general rule is the Internal Revenue Code or the Department of Revenue goes by the Federal Internal Revenue Code will allow a married couple to create this tax planning in your revocable trust designed to reduce or avoid the estate tax to the greatest degree possible, but only if you have this proper tax planning in your trust. But guess what? In our scenario, Mary is a non-U.S. citizen spouse, so they do not get the same tax treatment if she were a U.S. citizen. They would not get the provisions in their trust to reduce the estate tax unless they put QDOT provisions in their trust. So folks, that is the key here. If you are married to a non-U.S. citizen, and if you have or may have a taxable estate for the estate death tax, whether it's federal or state, okay, check your county in your state specifically. And if you are married to a non-U.S. citizen spouse, you need qualified domestic trust, also referred to as a QDOT, in your trust. So long as they put the QDOT provision language in their trust, you will still get the favorable tax treatment as two U.S. citizen spouses. Let's illustrate a little bit further. We'll say Bill checks out first, okay, $5 million estate. They're going to get zonked in the estate tax, but they put these super duper QDOT provision language in their trust, okay? So now they have to elect the QDOT election with their CPA or tax attorney within 9 months of Bill's death. QDOT election they have to make on the tax return. They have to make that and file that with the taxing authority within 9 months of the date of death. Extremely important, folks, not automatic. Then they have this QDOT language in here. It's a qualified domestic trust right here. We break it down into two sub-trusts, one called a marital trust, one called a bypass trust. The exemption amount, Massachusetts, is $2 million. So $2 million goes into the bypass trust. The excess goes into the marital trust, which is $3 million, okay? The money in the bypass trust goes down tax-free, maybe to their children perhaps. And the marital trust is tax deferred, and that will be taxed when it goes to the kids later but the money in there is going to grow tax deferred. And guess what? Mary can utilize the money in both trusts, principal and income, during her lifetime. The caveat here, the little thing, a little bit different with the QDOT, Mary cannot serve as the trustee. The trustee here, because she's a non-U.S. citizen spouse, has to be a U.S. citizen. That is because the IRS rules and regulations require it that way. So when Bill and Mary are designing their trust with your state elder law attorney, it's important that the attorney asks them, who do you want, Bill and Mary, as your trustee? They pick another family member who is a U.S. citizen, or maybe they have a child who is also a U.S. citizen. They pick their number one pick, the most suitable child, their Tom Brady, so to speak, be their trustee that can manage the money for the benefit of mother, the non-U.S. citizen spouse. Folks, there you have it right there. QDOT. You need to create QDOT provisions in your revocable trust, folks. This is not a do-it-yourself project, folks. You need to work with your attorney, an experienced estate elder law attorney in your jurisdiction, in your state. Folks, click the subscribe button. Share this video with others that you care about. Now go get that QDOT.